Megan said, I'm an attorney at Disability Rights Arkansas. I'm the legal director there, and so I supervise all of the attorneys and advocates. Disability Rights Arkansas is a federally funded nonprofit that provides free legal services to people with disabilities in very specific areas. We also investigate abuse, neglect, and exploitation. There's one of our organizations in all 57 states and territories. We're independent from the state and the federal government. We practice in several different areas. Very important to this one is, of course, access to special education and related services. This is a very ambitious subject matter to get through in an hour. I wanted to do kind of an overview of special education very briefly, and then get into some common issues that you as attorneys, as practicing attorneys, might see from callers. You might not practice special education, but having an idea of how to issue spot and perhaps directing them where they can go to achieve some kind of resolution would be helpful to you all in your daily practice. So that's the objectives for today. An overview of the IDEA, how it's structured, the common issues, the laws that correspond to that, the school district's obligations, and then direction to how to remedy any potential violations if those exist. So the IDEA, it is a law protecting students with disabilities, and that might not be fair. It's a law ensuring access to education for students with disabilities, and its history is somewhat entwined with the history of education of all children. Going back to Brown versus the Board of Education in 1954, we established the right to education. Following that, the court observed the right to due process for individuals in accessing education, particularly individuals with disabilities. That same year, 1972, they established the idea that funding must be equitably spent and called on Congress to make changes into how it structures education funding to ensure that schools had enough money and resources available to them to educate students in a way that would give them true access to education. So in 1975, Congress answered the call and they established the Education for All Handicapped Children Act in 1975. This is the first time that we had a federal law that truly outlined all of the supports and services and processes that should be in place to ensure students not only have access to education in a way that is equitable with non-disabled students, but also to provide them safeguards and protections to make sure their due process is afforded to them and their families. Name change and some minor changes happened when the law was reauthorized in 1997 and changed its name to what we have now, the Individuals with Disabilities Education Act. So we have three primary laws that really protect students, and protect might not be a fair word. Again, ensure access to education for students with disabilities. One of the ones that we work in the most often is the IDEA, Individuals with Disabilities Education Act, and that is special education law, right? When you talk about special education, you're talking about the IDEA. Other laws are ancillary in some ways to special education and education in general, but they overlap in several different ways with the IDEA. Section 504, it's a anti-discrimination law, and it applies to any entity that receives federal funds. That includes necessarily school districts. Right? School districts cannot discriminate against a child who has a disability as the recipient of federal funds. Similarly, a school is a state service, a public service, a public benefit, and so Title II of the Americans with Disabilities Act. That is a civil rights law, and it prohibits discrimination on the basis of disability. They function in different ways. They have different remedies. They have different requirements, but there is some area of overlap. Similarities between the IDEA and Section 504, for example, both of them offer educational plans that is at no cost to the parents. The plans in both circumstances have to be developed by a group of people. Both laws guarantee access to a free, appropriate public education. They both include a requirement for parental consent. And there are multiple ways to resolve disputes in both laws. Differences, obviously, there's a type of law. One is an anti-discrimination law, and the other is a very specific law that prescribes all of the services that a school must provide in order to meet educational objectives without going so far as to establish curriculum. Qualifications for who might be eligible under 504 or an IDEA differ. There is a much smaller group of individuals who qualifies for special education than just individuals with disabilities who might be eligible for protection under Section 504. And then the procedural safeguards that are available. As we'll talk about later, the IDEA has very specific due process requirements. They have a whole hearing framework that is administered by the state's Department of Education that details, it outlines how these hearings will take place, what evidence is appropriate. Section 504 simply requires that there is a hearing process to some extent. Compare that with the ADA, right? That is civil rights law that provides access to public services and public accommodations. It offers protections in employment. Title II, primarily the purpose of this presentation applies to public services. That includes public schools. It includes prosecutors' offices, state offices. Title III governs public accommodations. Think of retail stores, doctors' offices, public buildings that might not be a public service. Some school activities could actually be considered falling under Title III. Think of football games or school performances that might be open to the public. So under the ADA and 504, under either law, you can't discriminate against an individual, a qualified individual with a disability. And 504 and the ADA similarly define who is an individual with a disability for the purpose of that law. The remedies differ pretty greatly. You can get equitable remedies. You can, obviously, a court or a hearing officer in the IDEA could order a school district to do things, right? Those equitable remedies. Damages not available in the IDEA unless you're considering damages as a function of compensatory education or services. Section 504 in the ADA, however, damages are available in addition to equitable remedies. And beyond that, exhaustion requirements differ between the IDEA versus the ADA in Section 504. You're not required to exhaust under 504 or the ADA in the same way that you would be required to exhaust your administrative remedies available to you under the IDEA. When I mentioned that very specific framework for due process hearings, that is a process that you have to exhaust completely in order to be able to take a claim to court. Whereas with 504 and the ADA, after recent court decisions, even if it's on the same issue, you would be permitted to jump straight to court. So the framework of the IDEA, it's divided into several different sections, as you can see from your screen. General provisions, as with most laws, findings and purposes in Section 1400 One important section is in 1401 as definition section. It's one of my favorite sections because it really does lay out significant substantive law when it's applied to the following sections at least in the IDEA and many other laws. Our presentation today is going to mainly focus on Part B, and that's going to apply to K-12 children. We're not going to be speaking about Part C, which assists infants and toddlers with disabilities. It's a different framework that provides similar services, similar opportunities for representation, but Part B is going to be the main focus. So, as I said, the definition section, one of my favorite sections, because it really does start to give you an idea of who this applies to and how we're going to set up this framework later on. Child with a disability is very specifically defined, unlike we see in Section 504 or the ADA. We have very specific categories of disabilities, and it ranges from intellectual disabilities to emotional disturbance, even a somewhat catch-all category of other health impairments. But it's not enough to just have a diagnosis of one of those specific categorical disabilities that exist in this definition. You have to also need special education and related services. This applies to any child with a disability, but children aged 3 through 9, it's a broader definition that's designed to capture more children by having a lower standard for who will be considered a child with a disability. It's part of the federal government's commitment to ensuring access to services to youth. So we will pour services on children to ensure that they're helped early and they're helped often. IEP is another term that's identified in the definition section. IEP is going to be this foundational document, this writing that's going to be developed that describes all the services, supports, goals, objectives for a student with a disability. Your local education agency, that's the school district. It includes charter schools. All public open enrollment charter schools are their own LEA. There are some state operated facilities that are their own local educational agency, but usually the city or the school district that a child is in, regardless of whether they are in a private school or a public school, that local school district is going to be their local educational agency. Related services. So that's a term that you'll hear later on. Related services are all of the things in addition to education that a child might need in order to access their education. Think speech therapy, physical therapy, occupational therapy. It extends to counseling, psychological services, transportation, in some cases, diagnostic and evaluative medical services. If it's required for a student to be to benefit from special education, related services are available to them. What is special education? So we saw in the definition earlier of a child with a disability that in order to be eligible for services under the IDEA, they have to need special education. Well, we got to know what special education is, and of course that's going to be defined. Special education itself is defined as specially designed instruction free to the parents that meets the unique needs of a child with a disability. Now that means, does the child need the curriculum modified? Is there something about the way the instruction is given to every student that we need to change it in order to ensure that this student with their unique needs is able to access it. Special education is a service and not a place, right? Growing up, I did not know that special education was anything other than the one classroom that we had at our school that housed the special education students, right? But special education is a service and not a place. As we'll see further on, you can receive special education services in absolutely just about any setting you could think of, ranging from in the general education classroom alongside non-disabled peers to even hospitals, at home, prisons and jails. Every setting, a child who is eligible for special education may receive special education services in that setting. I talked very briefly, I mentioned free appropriate public education, another term that's defined, special education and related services that are provided at public expense, under public supervision and direction, and without charge to the parent. It's got to be free to the family. It has to meet all of the standards that are outlined in state regulations as well as in the IDEA. Has to provide curriculum that is appropriate for preschool, elementary, or secondary school, depending on where the child is in their academic career. It has to be guided by a properly developed IEP, which is that foundational document we defined just a few slides ago. Free appropriate public education has to be individually tailored. It's got to be individualized to meet the unique needs of the child. There's not an allowance for form services, formulaic services that are provided to every child with autism, for example, or every child with emotional disturbance, or every child with an intellectual disability. Every child has the opportunity required by the IDEA to have their services individualized to meet their specific needs, and also not just based on the child's disability, right? Even though there might be some services that every child at a school receives if they have a particular disability, the services that a child receives has to be based on that individual and not their disability. That's kind of the background. I want to, and I'm making good time so far, so I'll pat myself on the back. Areas of high impact, areas that you all as lawyers might get frequent questions about, that you would be able to issue spot and direct potential callers, potential clients even, to resources to resolve any disputes that might exist. I divided them into 4 areas. The first being child find, followed by how we're going to develop the IEP, how the IEP compliance might affect a student, and finally, discipline. Let's start with child find. What is child find? Well, it's a term that's used in the IDEA that means that affirmative obligation that school districts have to identify, locate, and evaluate all children with disabilities who reside in their jurisdiction. It's the responsibility of every teacher and staff person to watch out for signs of the need for greater intervention. They're supposed to be on the lookout for children with disabilities and refer them to school personnel responsible for determining whether services are necessary. This includes children who might be highly mobile, migrant, homeless, but also those who are in private school and without regard to the severity of the child's disability. It doesn't just extend to students with verified diagnoses either. It extends to those who are suspected of having disabilities. Anyone who has knowledge of a child with a disability may refer the child, but the child cannot be evaluated without parental consent unless the school district decides to petition the state to override their decision. Under any circumstance, however, if they are given permission to evaluate the child over their objection, they can't provide services without parental consent. Now, while a parent can request evaluation and identification, the ultimate responsibility is on the part of the school district. We cannot solely rely on the parent to not only understand their child's disability necessarily, but also we cannot rely on the parent to know at all times that they can go through this process in order to access these services. We have those people in place at school whose job it is to identify, locate, evaluate, and ensure services are provided to those students. And they're trained on identifying those red flags, which we'll talk about a little bit now. Some things that folks might discuss with you, difficulty understanding instructions, behavior issues, difficulty with reading or writing, perhaps short attention spans, withdrawal, self-injurious behavior, repeated exposure to discipline, attendance problems, retention from advancing through grades, or otherwise being behind significantly academically, actual diagnoses of any disabilities or placement in alternative learning environments. All of those are significant red flags that should at least alert someone that we might need a referral to determine whether this child is eligible for special education and related services. The last one isn't so much as a red flag, but is a common retort that we hear that a child might be too smart for an IEP. Some children who are extremely intelligent might require behavior support, curriculum modification, related services. So there is no such thing as a child being too smart for an IEP, even if they're advancing from grade to grade. So once we've had a suspicion that a child might have a disability, we go back to that eligibility criteria that we discussed in the definition section. These are the things that we're looking for when it comes to eligibility. If the child fits into one of these categories and whether they need special education or related services. Now, some of these are fairly broad. Other health impairment is probably perhaps the broadest. It's one that a child with a mobility impairment would fit into, and also one that a child with ADHD might fit into. The state on their website has much more specific definitions that kind of help you drill down what might be necessary to identify whether a child fits within one of these categories. When they fit into one of those categories, then you move into, do they need special education and related services? So diagnosis does not by itself mean eligibility. Just because a child might have a DSM-5 diagnosis or some other diagnosis of an impairment does not necessarily mean by itself that the student is eligible for special education. What does that referral process look like? So you have a parent who thinks that her child might have a disability, or the school district has told the parent that they want to set up a referral. Once you have requested special education services or requested evaluation for whether that's needed, there is a timeline that commences, right? If a parent does a request, which I always recommend they put it in writing, it triggers these procedural safeguards and these timelines which act as protection to the student. It ensures the school consistently stays on the ball and moves towards whether we're going to identify this child as a child with a disability and eligible for services. So once that request happens, referral conference has to happen in very short order. The parent must be contacted to schedule it within 7 days. That referral conference is going to include individuals from the school who will sit down with the parent, and they determine what information do we already have, what evaluations might we need, do we have enough information already, and what is the game plan of how we're going to conduct evaluations if we need those. Those evaluations, they have to be completed within 60 days once parental consent is given. And again, consent's required unless, on the very rare circumstance, the school will petition the state to get consent over the parent's objection. Those evaluations, I will talk about the meat of those in a little bit, but after that 60 days, the evaluation and programming conference, where we determine whether the child categorically meets one of those definitions that we discussed previously, and also whether they need special education and related services and what that will look like for the child. So evaluations, it's a big word, right? Evaluations includes lots of smaller assessments, right? So I like to think of it as a big umbrella. This is a comprehensive evaluation, and within it, you have assessments of intellectual functioning. We call those IQ, right? They have adaptive functioning assessments. How does the child act behaviorally, or how do they function physically? Can they tie their shoes? Do they get along with peers? Also, there are some smaller included assessments that might identify more specific behavioral issues that might exist. There are evaluations that are assessments that can help determine if a child has a learning disability, or if they're likely to have autism. But also these related services assessments, all of those assessments, all of those related services that we saw in the definition of related services, those related services assessments are going to be included in this initial comprehensive evaluation. Any evaluation that a child needs in order to provide information to the IEP team of how we're going to structure this program for the child, those assessments, if they're necessary, can be included in this comprehensive evaluation. Once that happens, the comprehensive evaluation happens at least every 3 years, unless the school district and the parent agree that it's unnecessary. And in the circumstance that a parent disagrees with the process or conclusions of an evaluation, she has the right to an independent evaluation at public expense. So that's child find, very briefly, right? And take away from that, the school has their own affirmative obligation to identify students with disabilities, to evaluate them, and to ultimately provide them services if the parent consents. And is independent of a parent's role. A parent not requesting an evaluation or not referring their own child does not get rid of the school's obligation to conduct child find and to start that process. Second area is going to be IEP development. Once we've decided that a student is eligible, that he meets one of those categorical disabilities and needs special education and related services, what are we going to do? We have to develop the IEP. I briefly talked about the IEP earlier in the definition section. IEP is a writing. It's a document. The state has a form to fill out, and it can be quite lengthy, depending on how descriptive the district is, or the services, the amount of services and modifications the student requires. The IEP has to consider not only the child's needs, but also the child's strengths. It has to include the parent's concerns, and information from those evaluations from the previous slides, I apologize, skipped ahead. It has to consider whether behavior support is necessary, and that's positive behavior support, which means promoting positive behavior, activities that reward positive behavior as opposed to punishing negative behavior. Must address any communication needs. Think augmented communication, children who might require the use of a device to be able to communicate. Also needs to consider Braille instruction for children who might be blind, and language needs, perhaps for English language learners. IEPs have to have these very specific sections in them. Present levels of academic achievement and functional performance, right? That's a very long phrase that really just means, how's the kid doing when we started this, right? Where is the starting point of this child? So that we can look back and say, here's how we're progressing. It includes all of the assessments that the child has undergone, any difficulties that they're having specifically, if they've had any, if they've made any progress toward their goals from the previous year, those are outlined, any diagnoses. Really, it is just supposed to be a capture of how the child is performing at the time this IEP is created. Courts have gone back and forth on whether we should call this a baseline. Some have said yes, some have said no. I very candidly, I can't think of it in any other way than this is the baseline of how the child was doing at the time the IEP was drafted. And from that point, it is the rest of the IEP grows from there. IEPs have to have measurable annual goals. That is one that really can get tricky at times because goals can be tough to make measurable and objective. Goals can be academic or they can be behavioral. And I've seen lots of schools struggle with making behavioral goals very measurable and objective, including language like Johnny will experience or Johnny will have appropriate behavior 70% of the time is the goal. And appropriate is very tough to define depending on who's defining it. And that overall might have a percentage, it might be technically measurable, but it is an impossible goal to be able to track unless you're measuring every action of the child throughout the day. So this is where they can get fairly tricky. It has to include a statement of what are we going to do for the child, right? So we've got where is the child when we started this process? We've got our goals at the end, and then we have to have the statement of special education, related services, and supplementary aids and modifications. What are we going to modify? How are we going to get this child from where they started to meeting the goals? And then it has to have some more technical things. Will this child be participating in statewide assessments? If so, what accommodations will they need? They have to have very specific description of whether the child will be participating in the general curriculum alongside their non-disabled peers and the reasons for not placing them in the general education setting. And it's got to say how often we're going to give these services to this child, where they're going to occur, and how long we're going to do it. That's the frequency, location, and the duration of services. So all of these things, they're all parts of the standard state-approved form for an IEP. If any of them are blank, that is not that's a problem. Right. And so if you have a parent calling you with an IEP, some sections of which are blank, that is something that should be remedied. IEP is not written by a single person. It's not drafted by the special education director. It's written by a team of people. I'm not going to outline all of the specific types of people that need to be included. You have the citation here. Suffice it to say, it's more than just a couple of people. The IEP has to be in effect at the start of each school year once it's in place. They have to meet annually to modify it if it's necessary. If a child transfers within a state, the receiving school district has to follow the previous IEP until it either adopts the previous one or develops a new one. When we talked about the things that a IEP must have, we talked about the location of those services and the extent to which they're not participating with their non-disabled peers. See, the IDEA presumes that children with disabilities are going to be educated with their non-disabled peers in the general education setting. Period, right? To the maximum extent appropriate, the IDEA wants schools to educate all students with or without disabilities in the general education setting. Special education or special classes, separate schooling, removal of children, segregation, anything that takes them out of that general education classroom setting only can happen if the nature and severity of the disability is such that education in general education classes alongside non-disabled peers with the use of aids and services cannot be achieved satisfactorily. So it's this requirement that students with disabilities, even if they are severe, even if the nature of them might at first blush cause the IEP team to think that they cannot be in the general education setting, the IEP requires the use of supplementary aids and services in order to determine whether that can be achieved to their satisfaction. We should start, in other words, we should start at the least restrictive setting. And then if those needs arise, try to support them with supplementary aids and services, and then look to possibly changing the setting. Those continuum of placements for least restrictive environment, I've talked frequently about the general education classroom instruction. Some folks call it inclusion, some folks call it mainstreaming. I just prefer to call it the general education classroom. Special classes like resource, self-contained rooms, those are going to take a child away from non-disabled peers. Special schools, completely different buildings in which the students in the general education classroom are attending. Home instruction, instructions in hospitals and institutions. In some cases, places like therapeutic day treatment. Yeah. So in brief, the IEP should show where the child is starting, how we're getting to achieving the goals, what those goals are, how we're going to measure them, beginning to end. It should also describe all the facets of the supports and services that we are going to have in place for the child if the IEP team determines that it's necessary. That can get as granular as the number of minutes a child is receiving individualized instruction in math or speech therapy or physical therapy or counseling, what positive behavior supports are going to be in place. If there's a behavior plan, it should be referenced and incorporated into the IEP. What setting is the child going to be in, and what assessments we have conducted and the results of those assessments. So we talked about child find, the obligation to find and locate students with disabilities and how that's the obligation of the school district. IEP development, how are we going to develop the IEP and what should it say? Okay, next section is IEP compliance. So how do we know if a school is complying with the IEP? And I did struggle with this one. Common issues that we see, the IEP says a student is supposed to be receiving an hour of therapy a week, and they're not receiving it. Student is not making progress towards their goals. The school is not providing behavior support, even though the IEP clearly states that they should. They're not modifying the curriculum. They're not providing any of the accommodations that are in the IEP. So the relevant questions to ask at that time would be, number one, is it in the IEP? Does the IEP say the school has to do that? How is it described in the IEP? Is the parent perhaps misunderstanding how many minutes the child is supposed to be getting? If it's not in the IEP, did the IEP team consider it and deny it? Because the IEP team might have actually considered the service that the parent believes the child ought to be getting and denied it, or at least determined that the child didn't need it. But one important note at the end, why? Right? Why did they deny it? Because it's not enough to say, we don't have the personnel, we don't have anyone who can do that, we don't have the money to be able to provide that. If the IEP team comes to the conclusion that a child needs it, they cannot start from whether we have personnel to achieve this. They have to start from whether the child needs it. And if the child does need it, and the IEP team determines that, the child should get it. So if it's in the IEP, it's a fairly good place to start from, that if the school is not providing what's in the IEP, unless the parent has consented to it, it's probably going to be a violation. And that's my very in brief of IEP compliance. And technically speaking, the IEP, right, is a very specific document. If the school is not doing something in the IEP, that is a problem. If the parent hasn't consented to it or doesn't know it, or the IEP team doesn't realize it, if it's in the IEP, it should be happening. So moving on to discipline. It's a big subject. Common misconception that that students with disabilities are not subject to discipline. Generally speaking, that is just flat wrong. On the other hand, zero tolerance rules generally do not exist in the world of special education. The IDEA itself says that a school may apply or not apply any discipline policies to students with disabilities. However, it does not require a school to adhere to its discipline policies. So I always get my hackles up when I hear zero tolerance policies, because the IDEA definitely varies that quite a bit. The school may remove a child for violating the code of conduct, a child with a disability, including all of the removals that we see here: out of school suspension, in school suspension, expulsion, informally sending a student home, putting them in an alternative learning environment. All of those things as discipline would be available to a school. However, it does not eliminate the district's obligation to provide that free, appropriate public education to the student, no matter how egregious the act was that caused them to be subjected to discipline, and no matter how long the discipline is. Now, the ability of the school to remove a child as discipline is limited, right? There is a limit to that. They can't just expel a student with a disability in the way that they expel any other student who breaks the student code of conduct. there are protections in place, those protections that are afforded by the IDEA. Students are entitled to a meeting called a manifestation determination review if they are proposed for removal, if that removal is in excess of 10 days. The manifestation determination review has to take place within 10 days. And ultimately, the manifestation determination review will determine what is this student's placement going to be. The manifestation determination review, it doesn't have to be the full IEP team. It includes the school district, the parent, and relevant members of the IEP team as determined by both the parent and the district. Oftentimes when discipline happens, if a student is receiving mental health services, it is imperative that somebody with knowledge about what those diagnoses are, how they can manifest, would be present at the meeting. Because you have to consider at that meeting, number one, was the conduct that we're proposing discipline, did it have a direct and substantial relationship to the child's disability, or was it the direct result of the school's failure to implement the IEP? If the answer is yes, it did have a relation to the student's disability, then the school has to return him to school, to the environment from which they propose to remove him, and conduct more assessments, establish a behavior plan to address that behavior as soon as possible. And if it's a no, they can discipline them to the same extent they discipline their non-disabled peers. But they still, under either circumstance, have to provide access to a free, appropriate public education. The exceptions to that are carrying or possessing a weapon, knowingly possessing illegal drugs, and inflicting serious bodily injury on another person at school. And serious bodily injury is very specifically defined, and it is, when they say serious, they mean serious. It has to cause incapacity or a risk of death or disfigurement. So serious bodily injury might sound like something that school districts can massage a bit, but it is a very specific term in the IDEA. And that removal, if we're going to remove a child without regard to a manifestation of their disability, that removal can be for no more than 45 days. And they still have to provide free, appropriate public education to the child. Alternative learning environments, those are often presented to parents as a structured environment. We see students frequently as an alternative to discipline be sent to alternative learning environments. Oftentimes, we've had to go look at the specific state requirements for ALE placements. We've seen many students who are sent to ALEs with behavioral health diagnosis, significant needs when it comes to their mental health, without ever being identified or provided with special education and related services. So those are other things to look out for. So those areas of high impact, we've gone through them. Now what? Okay, we've seen that there's a problem. What can we do about it? And I'm going to assume that you are not jumping into representation of the parent in a due process proceeding, but I will have information about that on the slide. Opportunities for remedies, obviously direct them to an IEP team meeting, right? The IEP team can make many decisions, sometimes, well, in all cases, over the objection of the superintendent. The IEP team by law determines who or what services the child will get. They can attend an IEP team with an advocate. There are some professional advocates out there. There's an organization, Center for Exceptional Families, who can provide advocates to attend meetings. with parents, family members, friends, uh, anyone who knows the student can attend as an advocate with the parent for support. There are such things as facilitated IEP meetings. If IEP meetings are tense and or not productive, the Bowen School of Law, they have a program that will provide a facilitator to help keep IEP meetings on track. And my experience with those facilitators have been very positive. Another option, mediation. The IDEA describes the mediation process, allows schools and parents to participate in that. As with any mediation, it is voluntary. Nobody's going to force you into it. Nobody's going to force you to make a decision. And mediators can also be provided by the UALR Bowen School of Law. State complaints are a huge benefit to a parent, right? If there's any of these issues that pop up, if a parent makes a complaint to the Department of Education through the state complaint process, the state then is obligated to investigate the circumstances of that complaint and render findings about whether the school violated the IDEA. They have to do it based on a timeline to render their findings. They can order compliance with the IDEA. They can order compensatory education, compensatory services. They have a very broad authority to be able to remedy violations of the IDEA. Parents can make a complaint to the U.S. Department of Education, the Office of Civil Rights within the U.S. Department of Education, or the Department of Justice. Both of those, at least some time ago, were taking special education issues. And then finally, if you are representing a parent, there is the option of a due process complaint. Even without representation, parents can go through the due process complaint. It's like the state complaint process, except you, as the individual or as the lawyer, have more control over the process, right? When it's a state complaint, the state is going in and investigating. The state will render decision, issue findings. Due process complaint is an administrative hearing process. You have the right to present evidence. You have an actual hearing. You have a hearing officer who makes a decision. Some parents want to go through that process more because they believe that they have some control over how the evidence is presented. More likely their point will be made. Standard procedural safeguards. Nothing should happen in the IDEA without the parent getting notice before, during, and after is what I always say to parents. There shouldn't be any shortage of notice and an opportunity to respond. In addition to that, the opportunity to examine records and to participate in meetings. And I see we're nearly out of time. I'm going to show you one more slide just to guide you to some of these state or the federal regulations about mediation, the state complaint. Anything within 1 year can be the subject of a state complaint, and due process. Ultimately, if you're going to be representing a parent, you can take them through that administrative process. And I want to address some of the questions, if we have some in the chat. If behavior is part of disability, shouldn't it be included in IEP programming and ways to address discipline short of suspension and expulsion? Yes, absolutely. Yes. Sometimes we see, frequently we see, not all disabilities are always captured by that present levels of academic achievement and functioning, right? But you should have a description of all the disabilities that a child has, regardless of whether it fits under the categorical, one of those categorical disabilities for eligibility, because all of that is part of a child. It is very Very important to consider the things that are going on with a child medically, neurologically, et cetera, as that can all have some influence on behavior. How early on would you advise that a family have an attorney involved in the SPED process? When is it too soon? That's really tough. Each circumstance is different. If if uh, if they have a school who is completely being obstinate, um, having an attorney can do one of two things, right? It can either open up those conversations or it can close them off. Sometimes we have been involved and that has greased the wheels somewhat and made school districts maybe more amenable to their obligations. Sometimes it has completely shut down conversations about things that might not be specifically required to happen. Is the school district required to consider independent evaluations obtained by parents? Yes, and it's a very well worded question, because the IEP team is required to consider those independent evaluations. Are they required to adopt them as the truth? No, that's an IEP team decision, right, of which the parent is a part. Should the goals be centered on the child's performance or on services performed and response to intervention? Gosh, both, both for sure, because the goals have to the goals have to be tied in some ways to curriculum, right? And so you're not going to get away from what is the ultimate goal going to be. It has to be Johnny can add 2-digit numbers together with 80% accuracy by the end of the school year. So the goals are really going to be tied to curriculum standards, unless you're talking about behavioral goals. Then those goals are most likely going to be centered more on the child's performance. And the goals can be modified. You could have an IEP meeting 10 times during the year if you wanted to. So if the child meets their goals early, or decides to or is struggling to meet their goals, those goals can be modified with an IEP team meeting. How do you show the nature / severity of the disability is such that they need additional aids beyond the classroom with all the other students? My observation, my interpretation is that it is trial and error. You have to show, you have to try supplementary aids and services in a less restrictive setting, and show that we've tried and we've failed, and we don't have any other options at our disposal before we start looking at more restrictive settings. Does anyone offer training / education to parents about this information about IEPs? Gosh, we do. we do. The Center for Exceptional Families, I'll call them out again. They are the Parent Training Institute for the state of Arkansas, so they get federal funding to provide this type of information to parents, doing outreach, hosting trainings, in addition to that role that I talked about earlier, where they can provide an advocate. Let's see. If the school doesn't have resources / personnel to comply with the IEP or otherwise provide what the student needs, what is the remedy? Well, as I said earlier, it is a strange thing to say, but if they don't have the personnel and they don't have the resources, they better get it, because if it's in the IEP and the child needs it, they have to provide it. I've had schools work towards getting used to be called catastrophic funding from the state. It's not called that. High cost occurrences, I think, is the name they changed it to. So the state does have some funding that is available for those high cost occurrences that might exist when a school is trying to comply with its obligations. Let's see. If the behavior is a part of a disability, shouldn't it be included? Yes, I think I answered that one. Should it be included in the IEP? Absolutely, it should. Every disability that a child has should be in that present levels of achievement and academic functioning, and should be part of behavioral programming if they need any. U.S. Department of Education. It's a question about possible disruption in the U.S. Department of Education. The IDEA it's a federal law, and so it takes an act of Congress to rescind it. That law doesn't come without funding, and so yeah, if the funding slows, certainly that would be a problem. How would that impact the individual students and the family's rights? If the federal law still exists, the federal law still exists and the rights are still there. We do have state laws that adopt many, if not all, of those rights and protections that exist in the IDEA. Where is a due process complaint filed? Filed with the dispute resolution section at the State Department of Education, the Arkansas Department of Education. Their dispute resolution section is a wonderful resource for parents and lawyers. If you go to the Arkansas Department of Education's website, search for special education dispute resolution. Everything you need to file a due process complaint or to learn about that process is on there and easy to read. If a school or a team does not include a goal in the IEP, can the school later use that missing item to deny that compensatory education is due on the same deficiency? If it's not in the IEP, it goes back to the question I asked earlier. Why wasn't it in the IEP? Did the school just neglect to leave it out? Because all of those are going to get very fact specific and almost fact determinative. And something, let's say it's something that the school just neglectfully didn't put in the IEP, but everybody acknowledges should have been in there, and Johnny has not been working on it. That is how compensatory education will be determined. If the child was entitled to some kind of special education services, 10 hours a day of math, reading, therapies, then if there's ultimately a deficiency, we just have to come to a calculation of what that child is owed to get them back to where they should have been. Gosh, all good questions. If a school/team does not include a goal, and that's the same question. What advice could you offer if the cause of the discipline was behavior symptoms from a disability such as FASD, and the school feels it is simple defiance? Need professionals in the room, and not that the members of the IEP team aren't professionals. Need those specific professionals that understand FASD to provide some kind of information that is relevant to what happened and how that disability might be tied to that. Even though I don't know that this would bear much weight if I had to defend it in court, I take the DSM-5 with me to IEP meetings, right? That is at least a good authoritative text that I can thumb through and say, well, Johnny has oppositional defiant disorder. That's generally classified as these different characteristics. We know that Johnny did these things, so his diagnosis of oppositional defiant disorder is going to be hard for the IEP team to really dispute whether that behavior is a manifestation or not, if the DSM says it's a characteristic or common characteristic of that behavior or of that disability. Are any organizations currently filing due process complaints on behalf of families with limited needs? Yes. We have very, very narrowly tailored priorities. Right now, we have assisted families not just with state complaints, with drafting state complaints, but also representing parents in due process proceedings. We have a number of them that are pending currently. And in addition to that, we have a list of private attorneys who are handling those cases. I don't know which of them charge ahead of time or not. In some cases, they might take some on contingency, they might not. But if anybody is interested, pro bono or otherwise, in handling special education cases, definitely reach out to us, get on our list, and we are happy to refer parents to anybody we have a very small bar of special education attorneys in the state. And we need more of them. I know that I believe either CALS or Center for Arkansas Legal Services or Legal Aid 1 they currently have someone who is taking education cases. But yes.
Well, that looks to be about all the questions, Thomas. Is there anything else you would like to address before I end things?
If anybody has any questions, we can be a sounding board at times on special education issues, really on lots of issues concerning individuals with disabilities. We like to be able to increase the knowledge base of the bar when it comes to these, because anybody can be an individual with a disability at any time. And nobody is immune from it. And so we need to ensure that those protections are observed, and that people everywhere have the right to due process and to justice across the state. So I want to thank everybody for joining and your interest in this.
Yeah, and thank you for giving us all this great information. We had a lot of great questions as well. So to all our attendees, I just want to remind you, I'll be sending a follow-up email here shortly. It'll have your attendance form and any upcoming CLEs we'll be having, as well as a copy of the PowerPoint presentation, just in case if you didn't get it. If you have any other questions for Thomas, I'll put his contact information in that email as well. So again, thank you for joining us today, and I hope we'll see you at our next CLE.